Ladies and gentlemen, boys and girls, it's Diego with another fantastic video for you guys out there in K1 visa green card land. Remember, I'm not an immigration attorney, I don't give you legal advice, and I do not work for USCIS. This video is about very strict green card adjudications. Immigration has been directed by the State Department, by White House, whoever's in charge of running immigration, they've been directed to implement stricter rules for immigration filings. Now they're going to be emphasizing complete documentation over documentation of evidence, discretionary adjudication, and very soon mandatory e-filing and an updated naturalization standard. You guys pay attention, class. Stricter adjudication. What does that talk? What does that mean? Stricter adjudication. And what is discretionary green card policies now coming out of USCIS? Well, USCIS now treats adjustment of status, the application, as an act of administrative discretion rather than an automatic right. It's no longer a right in their mind, it is a benefit. And this falls under Policy Memo PM-602-0199. And applicants must demonstrate that their positive equities, such as family ties, lawful residence, tax compliance, employment, and community contributions outweigh any adverse factors like any prior status violations or unauthorized employment or any minor criminal records. Even if all statutory eligibility requirements are met, you're totally qualified for the benefit, officers may still deny the application if negative factors dominate. And consular processing abroad is now considered the default pathway for immigrant visas. Okay? Try to relax, guys. Now, this is important. There are no second chances for incomplete applications. USCIS officers now have full discretion to deny applications immediately in front of them if initial filings are incomplete or fail to establish eligibility. So if you miss a few things, if your package is weak, you're going to get denied. Requests for evidence, RFEs, or notices of intent to deny, they no longer have to be issued automatically. That's gone. So it's critical for applicants to submit all required documentation up front, okay, for their visas, for their green cards, 2-year, 10-year, and H-1B petitions and other immigration benefits. No second chances for missing documents. No or more RFEs. Mandatory e-filing is coming, okay? Now on August 11th of 2026, today is August 15th, 2026, USCIS can require certain forms to be filed online once they have been available electronically for a minimum of 180 days. And this guy is going to include forms such as the I-129, the I-130, the I-140, the I-765, and N-400 as of now. And if you are an applicant who doesn't have access to a computer, etc., you may request a waiver using Form I-936, though this is going to be limited in cases of undue hardship. So don't bank on getting a waiver. Also, very important, class, don't forget this. Your signature must be able to be read by immigration. Don't do a doctor's scrawl. Now, I'm not picking on doctors. A new signature rule effective on July 10th, 2026 mandates that each immigration form must have a valid original wet ink signature. Invalid signatures, including scanned, copied, stamped, or software-generated signatures, can and probably will result in a denial with the filing fee retained. They will keep the money. This includes also your letters of intent to get married for the K1 visa application. There is no opportunity to correct the signature on the existing filing. If they can't read your signature, they'll keep your money and deny your case. Now, let's talk a little bit about naturalization updates. USCIS has updated the naturalization process. You guys know this. They've introduced a new 2025 civics test, and they've strengthened the good moral character GMC review. Okay, so immigration officers now conduct a holistic evaluation of applicants and their contributions to this society in the United States. Are you in tax compliance, filing joint tax returns? Do you have any community involvement? Okay, and if you have any voting violations and false claims of U.S. citizenship, you're going to be in big trouble. There's also been some changes to the asylum process to reduce the backlog. USCIS can now refer asylum applications directly to an immigration judge without interviewing the applicant. This will streamline the process and prioritize timely adjudication and eliminate a bunch of fraud that's going through the system also. Okay, there's a lot of fraudulent asylum claims out there, in my opinion, more so than actual family-based green card applications. So, practical implications of all this: applicants must submit complete evidence at filing to avoid an immediate denial. Green card applicants should document positive equities comprehensively. What are you doing in America that is for the good? Include your employment history, family and community contributions. Now, I understand as a 2-year green card holder, going for a 10-year green card, you should be working. But if you are part of a retired community, etc., they'll take that into consideration. Now, e-filing is going to be mandatory for many forms soon. So if you are going to file for a green card, monitor USCIS announcements. Signature compliance is critical. Invalid signatures will result, no doubt, in a denial with no refund. Naturalization applicants should prepare for the updated civics test and enhanced moral character review. Okay, that's why I keep telling you guys not to leave the United States for a vacation or anything while you're waiting to become a U.S. citizen. It makes life easier for you. Now, all these changes collectively increase scrutiny, reduce automatic approvals, and emphasize procedural compliance. So make careful preparation and follow the guidance essential for all U.S. immigration applicants. Don't make any stupid mistakes. Positive things that you're doing in this country will strengthen your 2-year and 10-year and or renewing your 10-year green card application. Family ties in the United States. If you have immediate family members here who are U.S. citizens or lawful permanent residents, well, this would apply to the husbands and wives of beneficiaries on 2-year green cards, because now you're married to a U.S. citizen, so you are a family member in America. Your length of lawful permanent residence. Maintain a continuous, unbroken history of lawful non-immigrant status in the United States. Try not to leave the country. Go on vacation inside the United States, not outside. Economic and professional contributions. Are you contributing? Are you making good money in your job to the area where you live? Are you paying jointly with your American citizen sponsor federal taxes? Are you paying your state taxes? You got to do that, okay? And community and humanitarian records. What do you have documented as a volunteer work? Did you join the military? Do you have any civic engagements? You could join your church or your mosque, your synagogue. Do you have any caregiving obligations? You could join the Chamber of Commerce where you live. And very important, this is very important. Do you have any property ownership? Is your financial stability good? Do you own a home with your husband or wife? What are your assets? What is the equity in your home? Do you have any commercial investments? Do you have any significant financial ties within the United States? Buy certificates of deposits or stocks or bonds, etc. with your American citizen sponsor. Do you have any adverse factors affecting you, which is going to be creating heavy scrutiny of your case? Do you have a history of status violations? Do you have any history of periods of unlawful presence in the United States? Do you have any technical gaps, status gaps, even if it was forgiven by a statute under the Immigration and Nationality Act, which is Section 245K? Do you have any unauthorized employment? Have you engaged in unpermitted work activities, regardless of how long? Have you misrepresented or inconsistent, problems in America? If there's evidence suggesting that an applicant entered the U.S. on a short-term non-immigrant visa, like a B1, B2 tourist visa, or an F1 student visa, with a preconceived intent to permanently adjust status. You come in on a tourist visa with an intent to marry an American. Good luck getting your green card. It ain't going to happen. Unless you go back to your home country and file the I-130. Tax non-compliance or financial delinquency, unpaid taxes, tax filing errors, or unresolved government debts. Get it fixed before you file for your green card with your husband or wife. Do you have any minor criminal conduct charges against you, or in the past? Do you have any arrests or traffic infractions that do not rise to the level of statutory inadmissibility but reflect poorly on your character? Okay. Given these stricter discretionary framework rules now being enforced by USCIS, the policy memo PM-602-0199 applicants is in full force. Okay, and you must adapt your filing strategies to qualify for this benefit with stronger evidence. Don't forget, when you file your 2-year green card, 10-year green card, include a cover letter. Do not rely on basic forms alone. Include a formal cover letter writing and detailing and explaining how the applicant satisfies the statutory eligibility and why you deserve a favorable exercise of administrative discretion. Why should immigration issue you a 2-year green card or a 10-year green card? Include a cover letter. Also, don't forget, submit comprehensive evidence of your equities. Front load your application with tax returns, employment verification letters, proof of community involvement. Your name is on the deed to the house or to the apartment lease complex. You have proof of family relationships in the United States. And if you have any minor infractions, you must directly include them in the application and explain it. If your history includes technical status gaps, errors in immigration problems, address them directly in an affidavit. Explain the mitigating circumstances rather than waiting for immigration to contact you and ask you about it. Primarily, you're just going to be denied if you don't explain it and they find out. Now, evaluate consular processing now as an alternative. If an applicant has significant negative discretionary factors that cannot be mitigated, consular processing at a U.S. embassy abroad may offer a more straightforward, non-discretionary statutory pathway. Okay? Don't come to the United States on a tourist visa or a student visa and marry an American and expect to get your green card adjudicated within the USA. So let me conclude this, ladies and gentlemen. USCIS Policy Memo PM-602-0199 is an important evolution in U.S. immigration enforcement and administration. Okay? They are explicitly framing adjustment of status as an act of administrative grace and extraordinary relief. Okay? Federal authorities have raised the bar for domestic green card applicants. Now, while statutory eligibility rules under the Immigration and Nationality Act, Section 245, they still remain in full force, these changes are collectively increasing scrutiny. They're reducing automatic approvals and they are emphasizing procedural compliance, making careful preparation and legal guidance essential for all U.S. immigration applicants. So don't mess up the paperwork, ladies and gentlemen, boys and girls. You don't need an immigration attorney to file for a 2-year green card or a 10-year green card or a K-1 visa, but you got to pay attention to details and don't make any mistakes. You don't need to pay an immigration attorney $5,000 or $6,000 to put this process together. You can do it yourself for free, but you must pay attention to what you're doing. Follow my videos. Learn what I'm doing. Watch the videos that I've made. I've been processing K-1 visas and green cards for almost 14 years. And my beautiful wife, Karina, is from Venezuela, and she is now in the process of adjudicating her 10-year green card. Now, it's going to take about a year, but she's in the process, and we did not need an immigration attorney to do it. Thanks for watching the videos, ladies and gentlemen, boys and girls. Don't forget I do a live stream on Saturdays and on Wednesdays at 6 p.m. Central Time here from our little office in the Panhandle of Florida. And if you want to become a member of the channel, down here somewhere you can join as a member. Go to the members only videos and you will get my phone number and email address where you can give me a call, text me, email me. 7 days a week. I'm open 7 days a week. See you at the next live stream. Pay attention to what you're doing with your processing of your paperwork, and we're going to pull you over the finish line.
I'll be back.